Hello, friends. So today I'll be talking on this end of life care in India, legal, ethical, and practical nuances. So I'm sure this topic you can debate and deliberate for a whole day. And what is very intriguing to me is every conference of intensive care will have this subject with expert panels deliberating on this particular topic. But what was intriguing is when I asked all my senior trainees or any of my colleagues. So the clarity on this is very much lacking, despite so much of work that is being done by different communities into this particular area. And honestly, this can be asked as an exam in DNB or DM as to what is the end of life legal position in India. And the only doctors which I believe should know about this with a lot of clarity are intensivists and maybe palliative care specialists or who deal with death. So there should be an absolutely sound understanding as to what is the current situation. And this is fairly dynamic and fluidic because it has been changing over last 20 years. Our understanding about end of life in India, especially from the legal perspective, has been very dynamic since last 20 years. And every intensivist and the trainee needs to be absolutely clear as to what is the current understanding and what is the current nuance when we are dealing with end of life in India. So, as I said, this can be a very large topic, can be deliberated possibly for a whole day, and I'm sure many of you would have seen panels going on for an hour and even extending beyond. But I've tried to put it in a very concise way. Maybe next 10 minutes, I should be able to at least give you insight what is the current understanding and how we should look at it. When we talk about end of life care, be it in India, it is the same worldwide. It is the same. Why we say end of life care in India is because we are governed by our constitution and our legal framework, and that's where we need to have clarity in India. How do we adopt this? So end of life care anywhere in the world is governed by a lot of other dimensions. So when you look at end of life care, important dimensions that we are governed by is the legal framework. So we are governed when we talk about end of life care to a patient, we should be aware about what is the legal framework that we are governed. And there are institutional policies that govern end of life because I'm sure every listener here who are working in various hospitals and healthcare organizations have different sort of institutional policies which govern end of life care in respective institutes. And then there is a public policy as well, which governs end of life care. And then there is a societal belief system or thought processes or policies that govern end of life care. Most importantly, the attitude of the physician or an intensivist or any of the primary care physician who is dealing with end of life and his approach, the clarity and his thought process and attitude towards end of life also becomes terribly important in trying to adopt the sound principles of end of life care. And last but not the least, in a country like ours, which is a diverse country, there is a lot of religious beliefs. So there is a belief system also which influences. So when a question of end of life is asked, I think one should have good clarity as to what are all the different dimensions that influence end of life care and just put it in a very pictorial way so that you can keep this in mind. These are the different dimensions which influence end of life care anywhere in the country, anywhere in the world. In India, the factors that have been identified as having enormous influence, or if you can say impediments, is the legal. So the legal framework and the institutional policies have found to have a more bearing on influencing end of life care. Of course, there are societal policies or the public policy or the physician's attitude, belief systems, all these have a underpinnings, but predominantly the impediments has been from the legal framework and from our institutional policy. So this talk, I'll only talk about the legal perspective because there is a separate talk I've given on the Breaking Bad News where I've looked at the medical understanding of end of life and the ethical standpoint. So let us very briefly look as to how the legal proceedings have happened in India. So we looked into the legal evolution enabling limitation of life support in India. So in 2006, so Law Commission of India, so whenever a question is put up to our legal framework, the case gets referred to Law Commission of India, which prepares a detailed report as to their opinion on this. So in 2006, Law Commission of India, they've come out with multiple reports. So for all the trainees, you need to understand these, you need to at least remember some of the key reports. The 196th report that came in 2006 Law Commission. So it clearly delineated euthanasia from the foregoing life-sustaining therapy. So FLST is foregoing life support therapy. So they delineated clearly that withdrawal, withholding, which all come under foregoing life-sustaining modalities or therapy, is separate from euthanasia. So because this is where we have sort of a criticism as to using the word euthanasia, but somewhere this word has been continued to be used because euthanasia is termination of life as a primary intent. So your whole intent is to terminate the life. So in withdrawal, withholding, or uh, or liberating from the life-sustaining therapy, all this should possibly not come under the ambit of this word euthanasia. Then they started using passive euthanasia. But in at least the 2006 Law Commission 196 report at least was clear enough to say that we should separate the word euthanasia from foregoing life-sustaining therapy or withdrawal or withholding. But they did exercise caution on legalizing advanced directive AD, because I'm just using a short word. AD is advanced directive. So the 196 report did not legalize advanced directive or the leaving will, whatever you call, because they did fear and dread that there can be a lot of mishaps that can happen in collusion of families and doctors in withdrawal of life support. So they did not legalize advanced directive. And in 2012 and 2014, so further reports came from the Law Commission of India where they tried to tweak these foregoing or withdrawal or withholding of life supports with lot of checks and balances. And they did put emphasis on patient's autonomy and shared decision making. When we say shared decision making, where decision is made in consensus with the patient's expressed wish, family, and the treating teams, keeping the values, preferences, and goals of the patient. So this, the Law Commission of India was sensitized to this aspect, that the autonomy of the patients and the expressed wish of the family have to be borne in mind when we are talking about withdrawal or withholding or foregoing life sustaining therapies. And they put checks and balances. But still, even though they did uh, so they did acknowledge that the autonomy of the patient and the family should be respected with regards to the values preferences. But still in 2012, they did not allow possibility of advanced directive. Even then, it did not allow. So from 196 report, there were multiple reports that came. The 241st report also did not allow advanced directive. So we are that's why I said 20 years. We are talking about 2006, and until 2012, there was no real progression with regard to allowing advanced directive to happen. So we have progress from there. So there's a lot of effort that has been put by various agencies to see some progress in this. So this is how we have progressed from 2006, where even an advanced directive could not be made for a patient. But then slowly there was a subscription or acknowledgement that patients' autonomy and expressed wishes of the family in tandem with the treating team should be considered, keeping the values, preferences, and goals of the patient was considered. Even in 241st report, advanced directive was not allowed. So at least there was an acknowledgement that there should be proactively, one should be able to understand the quality of death, and then they put in the processes in place that there should be some sort of a processes that need to be adopted for this advanced care plan. And then there were a lot of societies which put in effort to define as to what are the SOPs that needs to be followed when we are dealing with death in a terminally ill patients and taking care of the bereavement family. So there was a position statement that came from our intensive care society as to how we should adopt ethical principles in dealing with the death and facilitating the death and taking care of the families even after the death. There was a good position statement that came in, and this was also acknowledged by the legal framework that the process of death there should be some SOP that needs to be put in place to facilitate the process of death. So in 2000, so until from 2006 to 2012 to 13, nothing happened. In 2017 and 18, so the Supreme Court of India came out with a legal framework that allowed advance directive withdrawal and withholding. So this was a major step that happened from 2006 to 2017. So it almost took a decade for the Supreme Court of India to provide a legal framework acknowledging until then advance directive withdrawal or withholding was not happening. So this was a major sort of a paradigm shift that happened in 2017-18 when Supreme Court put out uh, the legal framework for withdrawal, withholding, and advance directive to happen. That's when the leaving will was allowed. So this was a major step for a community like intensive care, where at least there could be a glimmer of hope, where one could look at a process to adopt withdrawal or withholding. And at that point of time, Mental Health Care Act in 2017 also acknowledged that advance directive is something that needs to be allowed. And but they put a very sort of a stringent process in place, which was impractical. So at around same time, so there was a case, common case versus Union of India on 9th March 2018, which allowed the right for advance directives. As we say, there is a right to life based on a similar argument. So in this case, the judgment that came was there is right to life, and patient has a right to determine an advance directive. So patient can say what needs to be done when he becomes unwell and what should not be done. So that right to advance directive came into existence in 2018. And extending that nuance, so refusal of life sustaining therapy also was accepted upon or was agreed upon. So this was a major sort of a breakthrough happened in 2017 and 18 when the judiciary or the legal framework acknowledged and accepted that foregoing life-sustaining therapy, advance directive, withdrawal, withholding is something which is patient's right and it should happen. So that is the first. So that is the year where the breakthrough happened. But then the whole question is, all this is fine for someone who is in a clear conscious state and who is able to work towards it. Suppose I think this is something which can happen in someone who has a progressive disease or a very advanced cancer where he could work through this. But what do we do in a patient who is on a ventilator or is incapacitated to do any such decisions? That's where the whole discussion was. How do we have this advance directive for someone who is not able to make a decision when they are so incapacitated, then one has to depend on the family to make a decision for the patient. So this is where there was a bit of a non-clarity or a dichotomy. And for this, the Supreme Court of India, they put a three-tier process, which made things very impractical. So they said if you have to have an advance directive, withdrawal, or withholding for someone who is on a ventilator or who is incapacitated, then the three-tier process suggested that one should, I will talk to you through the process. So the three-tier process involved the concurrence of district collector or judicial magistrate of first class, JMFC, so judicial. So this is, I'm sure every listener know, this is hugely impractical that trying to reach out to a district collector or judicial magistrate of first class and gaining their concurrence that a withdrawal should happen is very impractical. So this was a humongously impossible process that the judiciary put in place, which obviously, which none of our intensive care community could work through with this sort of a process. So when this happened, when this three-tier process was put in place, then there was an appeal made. There was an appeal made to the court of law, to the Supreme Court by Vidhi, which is an organization where Dwani Mehta, who's been in many of the panels in our intensive care discussion. So the Vidhi, which is Center for Legal Policy, and ELICIT. ELICIT is a group of physicians. ELICIT is End of Life Care in India Task Force. So this obviously this involves our Indian Society of Critical Care Medicine and Palliative Care Society and various other organizations. They come under this umbrella of illicit. So they put up an appeal to Supreme Court that this process has to be simplified because it's too complicated that intensivists cannot run to a district collector or district magistrate of first class. So they have to simplify. So there was an appeal put in, and our intensive care society also was involved in this appeal. So this is an important thing that one needs to be sensitized to as to the process that has taken place to come to this stage. So for that, the Supreme Court made a five-bench judge. So there was a five-bench judge panel that was created. So this also came out with a landmark judgment saying that this five-bench judge said, yes, they did acknowledge this three-tier process is very impractical, and they got away with this magistrate of first class or the collector. So going to the collector and getting their concurrence is not needed was what was directed by this five bench judge. But what they said was that, but still it needs concurrence or attestation from the gazetted officer. So this is what they said. And they reduced the three-tier process to a two-tier process. So this is what happened post appeal from Elicit and the Vidhi, that the judges simplified the process from the three-tier where it was meant that it had to go to judicial magistrate of first class or district collector. They brought it down to two-tier process where gazetted officer attestation was good enough is what they said. But they did mention that the district magistrate has to be intimated or informed, but their concurrence or the presence is not needed. So now, what is the current legal sort of a provision that we have if we have to facilitate end of life in a legal way? So I'm using the words in a legal way. If you have to facilitate end of life, I'm sure every intensivist who's listening to this, they would be adopting end of life principles as laid out in our position statement in an ethical way. But if we have to enshrine this in a legal way, what are the procedure? Please pay a little attention to this process. So right now, the legal provision that we have, if we have to do end of life in a legal way, so we have a patient on a ventilator who is incapacitated, who is not able to make a decision, or we are dealing with a terminally ill patient who is incapacitated to make a decision, then so the treating team should decide whether the continuing this life support is not beneficial or futile. Once the futility is established, where we know for sure that continuing this life support therapy is of no benefit, then there has to be a primary medical board that has to be created, which is called PHMB. These are all enshrined in our legal framework now, which is the primary hospital medical board, which is if you are working in, say, I'm working in Manipal, I need to create medical board within this hospital, which consists of three doctors. So one should be the primary physician. So I consider myself an intensivist. So I am a primary physician looking after a sick patient. There should be two other subject experts, and that is defined as more than or equal to 5 years of experience. So there should be a primary hospital medical board consisting of three, and all these three should have concurrence that continuing life support measures is futile and withdrawal or withholding of life support has to be done. After this, this uh, this this particular thing has to be counseled within 48 hours to the family and all the members who are recognized or identified as the immediate family members. And it also mentions it could be the next of kin, it could be relatives, or it could be even the guardian. But whoever is identified as their family member should be involved in the conversation, and this has to be communicated. After this, what is more important is there is a secondary medical board which has to be which has to be referred to. So once a primary medical board makes a decision, withdrawal, withholding can happen. Once there is a concurrence within them, and once there is a concurrence with the family after this has been communicated, secondary medical board has to be created. I mean, has to be referred to. So secondary medical board also consists of three doctors. So one of them is an empaneled specialist by district CMO. So district chief medical officer should have impaneled. So it is like a brain dead. So in brain dead, we have, at least in our Karnataka, it needs to be authorized by four doctors. Two should be empaneled doctors. So it is very similar. Here, secondary medical board should have an empaneled doctor by district chief medical officer and two subjects who are outside the domain of this primary medical board. So two subject experts, again with more than 5 years experience outside the primary hospital medical board. So this secondary medical board, if they are in concurrence with the decision of the primary medical board, so the secondary medical board concurs with the primary hospital medical board, and this concurrence should happen within 48 hours after the case is referred to them. So after that, the hospital, once there is a concurrence between the primary hospital medical board and the secondary hospital medical board, hospital should notify judicial magistrate. When it says before, it used to be you needed a concurrence of judicial magistrate. Here there is no need for concurrence, but hospital has a due responsibility to just notify and send a intimation to judicial magistrate. This is what is the two-tier process. After notification, you don't need to wait for approval from judicial magistrate. You just have to notify once there is a concurrence between the primary medical board and the secondary medical board. Then the treating teams can initiate withdrawal or withholding. So this is the current legal framework which governs the legal way of initiating the withdrawal or withholding. Suppose secondary medical board has non-concurrence with the primary hospital medical board, then family, if they still pursue or if the treating team still feel that withdrawal has to happen, if you have to confine to the legal framework, then the family has to approach Honorable High Court of the state. So this is the current legal provision available at this point of time, and all these changes or the appeal and the two-tier process that happened, it happened only in 2023. All this clarity has come in now. And today, as we are speaking on 5th September 2000, this is the current legal provision that we have. If we have to take, if you have to conduct a withdrawal or withholding, enshrining the legal framework. So, but having said all this, so then after this report came and after this, so the British Medical Journal, as you see, it is dated June 28, 2023. So they had an editorial that came out looking into the legal framework that is governing our withdrawal. So here the comments made by the editorial is Article 21 and 14, although they make a reference to withdrawal and withholding and right to advance directive in the current order, but they continue to use the word passive euthanasia, which is something that is not in keeping in the essence of our withdrawal, is what uh, the authors do subscribe to, because the usage of word euthanasia has to be removed from this whole document is what their thoughts are, because the euthanasia word itself is not in keeping in essence with the sanctity of death that needs to be facilitated by withdrawal, because it puts enormous burden of guilt by using this word euthanasia, and this burden of guilt is passed on to the family and to the treating team. So this is something that the observation that these authors make, and even the using of this word passive euthanasia will have objections from the religious sort of a belief system that we may be governed with. And even the BMJ author to put it as being very impractical. Even with the new two-tier process, the BMJ authors feel that it is impractical to adopt this process of creating primary medical board, secondary medical board. And this may act as an impediment for withdrawal and withholding is their thoughts. And the important statement they make is, okay, we make an advance directive. Suddenly, families say they want to revoke the advance directive. So we do not know the process that is put in place to revoke the advance directive, and that is even more cumbersome. So still, there are a lot of gray areas, is what the author observed. But my take is the process is definitely simplified. So we have to look from how we have moved on from where even there was no provision for advance directive in 2006, And until 2012, there was a lot of effort trying to put in to create an advanced directive, and there was no legal provision even for advanced directive. We have come a long way where now 2017 Supreme Court makes an allowance for advance directive and withdrawal and withholding to happen, but they only put the process, and even the process, which was a three-tier process where we all felt it is impossible, is at least simplified. Right now, so look at it this way, we can create a primary medical board. It is not difficult. So now the effort has to be put in to create a secondary medical board. So once this process is streamlined, just notifying the judicial magistrate if a channel is created from the hospital where a notification goes saying there has been a concurrence. So there is a reasonable legal provision for us to adopt this process. But the challenge is after this provision has been made and these amendments have been made and 2023, we have this two-tier process. My question to the audience is how many hospitals have at least created a primary medical board? Have they created? I do not know for sure because in my hospital right now, there is no primary medical board at this point of time. So maybe that is the first step we should start off, create a primary medical board, reach out to the district CMO and request them to create a secondary medical board, like how we do it for our brain dead patients. And this is something where the effort should possibly happen from our side because legally the judiciary has taken many steps forwards and have made this provision. So it is time for our community also to put in little effort and take few more steps. And I'm sure in days to come, this is going to get a lot more simplified, is what is our hope and belief is. Uh, so we need to applaud our judiciary that they have put in good efforts and they have acknowledged our concerns and they have taken good steps in coming. Although BMJ says that it is impractical and it would create it would still create impediments for withdrawal. But I think from my perspective, I would look at it as they have taken a lot of steps forward. And creating a primary medical board is not a difficult thing, and facilitating the secondary medical board also is something that is something which is practically feasible. And notifying judicial magistrate if a channel is created, some hospital is working, and this is a workable solution. Is my thoughts at this point of time. But I'm sure in the days to come, it will be a lot more simplified. So having said all this, there's a lot of work put in by a lot of people, a lot of institutes, and to that effect, even I've done my medical law and ethics from National Law School. My project was end of life care in intensive care, legal and ethical. This is a 100-page sort of a project that I submitted as a part of my project to National Law School, and we had even drafted a white paper with National Law School towards this effect. And a lot of work has happened from this group, illicit group, and there is a detailed document sitting on the website. So any of the trainees can go through the whole sort of a narrative that has happened with regard to end of life care in India. This is around 40-page document that is there on the website. You can go and look into it as to the whole sort of an ordeal that people or the institutes had to put in to come to where we are with regards to end of life care in India. So I hope I made reasonably clear as to what the current understanding of it, because before I gave this narrative, I was asking a lot of my trainees, none of them had any clarity as to what is the current understanding. So it is good. And if I have to say one question that needs to be asked in every exam in critical care, it should be end of life because it is intensively to deal with end of life, and every trainee should have absolute clarity on what is our current legal standing. So thank you one and all. I request every listener to consider submitting your valuable work to this Journal of Acute Care, which is a quaternary journal. So we have issue coming out every 3 months. So do submit your valuable work. You can visit my website www.drpradeep.com to rehear to this. So thank you one and all. End with this beautiful quote: "Death is not the opposite of life, but a part of it." Thank you one and all.